Professor, thank you for joining us. We will do a proper introduction when everyone's back.
Perfect, thank you.
Brian, if you can hear the sound of my voice, we're ready to proceed.
Yes, I can.
Welcome back. We have our quorum back. Brian, would you introduce our guest, please?
Well, I'm going to ask her to introduce herself because I'm not as fresh on the details of her bio. And I don't want to give her short shrift. So Aushra Deluard of Dentons, I believe. If you could let us know a little bit more about your background in antitrust. I see we also have Professor Green sort of lurking in the background, which is perfectly fine. But I'm not expecting him to present today. I think he just wanted to observe. So Aushra, go ahead.
Thank you, Brian, and thank you, Commission, for this opportunity to be able to speak to you today about antitrust mergers. I am a partner at Dentons and also the co-chair of our U.S. antitrust practice. My practice for over a decade, I have been primarily focused on antitrust merger work. So that's everything from the pre-merger notification filing, counseling companies, risk assessments, and then also helping companies navigate merger investigations and then remedy any concerns that they might have on that. Both representing clients before the U.S. antitrust agencies, the Federal Trade Commission and the Department of Justice, as well as state AGs when they join and investigate as well. I also teach with Professor Green at used to be UC Hastings, now I think San Francisco Law, I'm not quite sure, Professor Green. So I teach the course on antitrust with Professor Green, and I cover the antitrust merger section. So I look forward to giving you a whirlwind tour of antitrust merger law, both from a federal perspective and also what's happening here in California over this time that we have together. So Brian, I do want to share my slides, but I saw that I'm disabled from participant screen sharing. So I sent those over to you if you want to upload those. And just to give you an overview as we sort that out, what we're going to cover today is, kind of broken up into two sections. One is the procedural merger review. So how do the agencies, how do the states actually get to review transactions? What is the framework that we have in place for that? The pre-merger notification system on the federal side, and then also working through how California and discussing how California has joined some of these merger investigations, and also how they have their own pre-merger notification regime in healthcare. So we'll work through those slides, and then I'll touch on substantive antitrust merger review. So how do we interpret Section 7 of the Clayton Act, which is the law that applies to determining whether a transaction is anti-competitive or not? It's quite simple. Will the transaction, does it, oh, sure, Brian.
I'm not seeing your slides. Did you email them to me?
I did. I just emailed them to you shortly before 11 o'clock.
Yeah, I'm sorry about this. I thought that you should have had sharing capacity.
Happy to share as long as they can provide me access to do so.
Yeah.
Oh, wait,
Well,
I do have it now. It's working.
Okay, perfect.
Someone just clicked a magic button, so we're working. Okay, excellent. Okay, can everyone see my slides? Perfect. Okay, so we're going to start with, as I mentioned, the framework. How do we review these transactions? And then we'll get into Section 7, how it's been interpreted, the horizontal and vertical merger guidelines, and what's happening today. Because right now, as we speak, those merger guidelines are under consideration. And we anticipate a pretty significant revamping of the merger guidelines, which has really guided the agencies, businesses, and the courts in how, the agencies are going to be evaluating transactions going forward. So we'll get into the substantive review after we talk about the framework. Okay, so to start, in 1976, the Hart-Scott-Rodino Antitrust Improvements Act was enacted. The reason why we enacted this was because you were seeing a lot of transactions that were occurring, and then they were closed if you didn't have kind of pre-warning of these transactions. And then you have to unscramble the eggs, right? You're trying to, essentially, the companies have already integrated, and then you're asking them to separate, and that can create all sorts of problems. The information has already been shared. Your employees have already, there's been significant changes that have been made, assets perhaps reallocated. And so by having a pre-merger notification, what that allows us to do is to be able to inform parties before they close their transaction, before they integrate, whether or not we have concerns with the transaction. So we can solve the transaction before it even closes, or block it. What that does, however, is that does make it into quite a predictive exercise. So in most laws, you have, the situation where you're essentially, you see an effect, and then you are prosecuting that effect. You're prosecuting the violation, the consequence, the actions. And here we are predicting whether a transaction will substantially lessen competition. So it really is very much of a predictive exercise. What the Hart-Scott-Rodino Act does is parties have to file, both sides, the seller and the buyer, have to file an HSR form and accompany that with a filing fee. Those filing fees range from $30,000 to $2.25 million, depending on the size of the transaction. It is a compulsory pre-merger notification if the transaction meets the thresholds. So the first threshold is $114 million, or $111.4 million today. That's actually based on a $50 million threshold that has been adjusted for inflation since 1976. So every year, this threshold is adjusted and usually published around February. If the transaction is valued over $111.4 million, then the parties also have to meet the size of the parties test, which means that one party has to have 22.3 million or more in assets or revenues, and then the other party has to have 223 million in assets or revenues in order to be notified that transaction. If the transaction is valued over 445 million, then the transaction is reportable regardless of the size of the parties. So that's and then there's a number of exemptions that apply, but that's the quick Cliff Notes version of HSR reportability. If the transaction has to be notified, an automatic 30-day waiting period is imposed on the parties. They cannot close their transaction until those 30 days have passed. There used to be an early termination program in place in which the non-problematic transactions could be notified before the 30 days expire in order to allow them to close earlier. So imagine a mutual fund investing into a company. It's a non-strategic transaction. There's no competitive effects. You're allowed to get a letter that says that. During the COVID, there was a high volume of transactions that were coming in. And so the agencies had suspended the early termination program. It was supposed to be a temporary thing, but we really haven't seen the early termination program come back online in full force the way it had been prior to 2021. At the end of the 30 days, if you haven't heard from the DOJ or the FTC, you're free to close. If, however, at the end of the 30 days, you receive what's called a second request, it's a request for additional documents and information. It's essentially a very extensive and burdensome subpoena. That issuance of the second request would extend that waiting period until the parties have certified substantial compliance, until 30 days after the parties have certified substantial compliance. However, in practice, that 30 days typically is a lot longer because what happens is the DOJ and the FTC negotiate what's called timing agreements. essentially timing extensions in return for narrowing the scope of the investigation. The investigation, the subpoena, the second request calls for all documents relating to from the company. So a lot of times the way the companies handle trying to respond to these investigations, especially imagine you have a 50,000 employee company, millions of documents, terabytes of data, is to negotiate what are the sources of information, who are the custodians, what are, what perhaps you might be negotiating about which relevant products or geographies should be included in the investigation. Any of those types of concessions are, kind of what the DOJ and FTC negotiate at the same time that they're negotiating the timing agreement. And so while they might not admit that it's a quid pro quo, in some ways, you typically don't get a timing agreement agreed to until there's also some sort of parameters as far as what the scope of the investigation is going to be to keep it in reasonable bounds. So currently what we're seeing is the DOJ and FTC negotiating for typically about 60 to 90 days after substantial compliance to be able to review all of the materials that they've received. And sometimes that can be extended if it's a very complicated transaction. We've seen timing agreements asking for 120 days. The second request typically calls for data, interrogatory responses, and documents. When we're talking about documents, it's very extensive. This includes emails, it includes text messages, WhatsApp messages. And it would, it's typical to have custodians, depending on the size of the transaction, about 30 people's whose files you're searching. And this results in productions of close to 1 million documents, is not unheard of. And it's actually quite typical in these types of investigations. It typically takes the companies, it's quite expensive for the companies to comply with these, hundreds of thousands of dollars, if not 7-figure fee amounts from legal and e-discovery vendors. And it typically takes them 3 to 6 months to comply with this type of an investigation. So it's quite burdensome for the parties. And it's also quite burdensome for the FTC and DOJ because they're receiving all of that information that they need to sort through and data and documents. There's typically economists involved on both sides, both for the FTC and DOJ, and then also for the parties. Failure to report. So if you don't report if you don't file a notification and you do have to, or if the parties close prematurely, start to exercise control over each other, start to influence each other's business decisions before the expiration of the Hart-Scott-Rodino waiting period, they can result in fines of over $50,000 a day. And that's adjusted every year as well for inflation. So there's quite, a significant program in place to be able to review this. Information that is provided under the Hart-Scott-Rodino Act is confidential. It is FOIA exempt under statute. So there are very strict confidentiality provisions here. The only exceptions are if you are, providing something to Congress or using it in litigation. And then if you're using it in litigation, the companies have the opportunity to seek a protective order to keep certain confidential information in camera. So what typically happens is the FTC and DOJ receive all of this information, and then states, if they are interested in the transaction, will seek a waiver from the parties, which essentially allows the FTC and DOJ to coordinate very closely with the states, sharing all of the information that they receive, allowing the state to attend all the depositions, attend any significant substantive meetings that the parties might be having with the federal antitrust agencies. So they're really able to benefit from all of the information that the parties are already producing to the federal antitrust agencies and to be able to piggyback on that investigation rather than issuing a duplicative, request for information. And so in almost all cases, parties agree to provide this confidentiality waiver to the state AGs. And again, the state, and then we'll, of course, negotiate and ensure that there's sufficient confidentiality protections with the state AG to protect that information as well. But that is how most state AGs are able to investigate, gain access to, and be able to, coordinate and be able to protect their resources and be able to, instead of duplicating the work, they're able to work very closely with the antitrust agencies. One of the things to remember is that most of the reported transactions, even though the threshold, you don't even start talking about HSR until you get to 111.4 million today. Most of the transactions reported are not investigated, right? So for almost all of, 98% of transactions don't receive a second request on average. So this appendix is from an annual report back in 2019. It provides you the metrics. It is typical for the agencies to receive anywhere between 1,000 to 3,000 HSR filings. In 2021, we saw a significant uptick in HSR filings. And that seems to have plateaued a little bit now. But it's typical, as you see in the numbers there, anywhere between, it could be 1,000 to 3,000 filings a year. The FTC has a pre-merger notification office that has a dedicated team to just processing, reviewing HSR filings, not from a substantive perspective, but just from a, clear, almost like a clerical perspective, ensuring that the notifications are complete and accurate, and then also responding to any questions. There's a number of questions during the HSR reportability. Even though this has been in place for quite some time, it continues to generate a number of questions from the bar as far as the nuances of the exemptions and the thresholds and how transactions are structured. So this team of about 10 personnel at the FTC are dedicated to also responding to those types of questions. So as you can see, about 2 to 3% of the transactions that are reported are actually then investigated through a second request investigation. So as I mentioned, the state AGs often investigate transactions with the DOJ and FTC through those types of waiver requests. Section 16 of the Clayton Act authorizes any person to seek injunctive relief against threatened loss or damage by a violation of the antitrust laws. This allows the state of California and other state AGs, especially through their Prince Patria powers, to be able to seek enforcement of Section 7 of the Clayton Act. And this allows them to, even if the DOJ or FTC settle a case, they agree to a consent decree, they decide to close an investigation, the California AG can still, under Section 7 of the Clayton Act, still bring a challenge to the transaction and negotiate their own settlement or seek to block the transaction. So this especially came into question when California sought to block the American Stores acquisition of Lucky Grocery Stores in 1998. And in that, the FTC had reached a consent decree in May of 1998. The transaction closed in August, and California filed, seeking to block the transaction and have American Stores and Lucky divest the stores in California to remedy the concerns that they had about the transaction. So here's a situation where the FTC had already agreed, closed their investigation, and California said, no, we need to do more to protect our state citizens. And this case went up to the Supreme Court as far as what were can California do that? Can they seek a divestiture? And the court said, absolutely. That the state and, Section 16 allows divestitures as part of the remedies that you can seek, through your Prince Patria. So states do and can independently challenge transactions on behalf of their citizens. Oh, one thing that I forgot to mention on the pre-merger notification process is that even though we have that in place, and even though transactions may be investigated, there might be a consent decree, nothing stops the Federal Trade Commission and the Department of Justice from investigating non-reportable transactions, consummated transactions, whether they're non-reportable or reportable, and even investigations that they had previously investigated and allowed to close. They can come back years later and say, we now see that there's anti-competitive effects. And we think that this is because of that transaction and because of the market power that you achieved in that. And so we're going to come back and we're going to challenge that. In fact, that's what we have seen the FTC with this, when they were so inundated with so many of these HSR filings in that 2021 period, they started to issue to companies letters that said, we are closing this investigation, but you close at your own risk. We can come back and we can challenge this transaction. And so, essentially that's just reaffirming that under Section 7, there's nothing, just because the Hart-Scott-Rodino Act exists, doesn't mean that they lose their power to come back and challenge a transaction or to investigate and challenge non-reportable transactions. So that is true for both the state and for the FTC and DOJ. So California has been, they have independently challenged transactions on behalf of their citizens. One case in particular, Summit Sutter, in 1999. This was a really interesting case. The government closed their case, and then California sued to try to block the transaction. They were concerned about the anti-competitive effects in the Bay Area, especially the East Bay, and their preliminary injunction was actually denied for failure to adequately plead a relevant geographic market. And so we'll get into, when we're talking about substantive antitrust review, relevant product markets and relevant geographic markets. This is an area that takes a lot of, there's a lot of contention, a lot of dispute about how do you, the plaintiffs might argue, the antitrust authorities might argue for a very narrow relevant market. The parties might say that that's not practical. This isn't how the market realities actually work. That market definition inaccurately, describes the marketplace. And so that's an area where a lot of time and effort is typically spent on. And currently it's actually, and we'll get into this as we talk later, it can also provide quite a challenge to some transactions. As far as you might see anti-competitive effects, or might be very concerned about something, but if it doesn't fit into a neat relevant market box, then you face currently under the current precedent, you face some obstacles in trying to prove that case. And so Summit Sutter, yep.
Oh, I'm sorry, before you move off Summit Sutter, so that I don't get lost, the failure to prove the relevant geographic market, was there simply a failure to articulate the market, or did they define it too large, too small? What was the actual defect on that one?
Yeah, they spent a lot of time. They had an economist. They definitely had defined a market, but the court found that they didn't define the market appropriately. So, they didn't include, for example, I don't know if you guys are familiar with the East Bay, but they didn't include La Miranda. They didn't include other areas that, based on the inpatient and outpatient kind of geography data, they felt should have been included. And so it wasn't that the state didn't, just miss that. They certainly pled a relevant geographic market, but the court disagreed. It was, it came down to essentially a battle of the experts, right? Talking about what is the appropriate way to look at this. And the court sided with the defense. And so they said, nope, you didn't do this accurately. You didn't do it. Case over, PI denied. And so this is why when we think, and I'll get into relevant, markets when we talk about the substantive part, but that really is an area that is up, there's a lot of school of thought on some people who are very adamant about absolutely you can't do antitrust without relevant markets. And then there's a whole nother body of thought that's saying, but aren't we trying to actually assess anti-competitive effects? And do you need a relevant market to be able to assess what the anti-competitive effects might be? So, and what's interesting, especially about the Summit Sutter case, is even though they lost the PI, you guys are probably familiar with the fact that the California AG negotiated a pretty significant settlement in 2021. Well, they negotiated it in 2019, and it was approved in 2021. in which, first it was the union. UEBT had brought a lawsuit in 2014 alleging anti-competitive practices by Sutter. And then the AG filed a similar suit in 2018, really about Sutter's business practices, that they were engaged in these all or nothing deals, they were bundling their products, essentially, in anti-competitive rate setting. So what this state AG thought was anti-competitive effects, essentially. So here you have a transaction where they failed in being able to block it. And 10 years later, they're coming back and saying, we now have, here's your behavior that we found is anti-competitive because of your market power. And so they were required to pay a $575 million settlement. They were also required to have certain restrictions, prohibitions on, business practices. They couldn't bundle, they couldn't have all or nothing deals. And they were required, and a monitor was imposed for 10 years to monitor their business practices and ensure compliance with that settlement. So that, reflects a few things. And one of them is that even if you don't catch a transaction in the very beginning, right, you also, because you have this opportunity, once you have anti-competitive effects, you can also litigate the anti-competitive effects. So the California AG has also, Anthem Cigna is a good example of where the California AG joined the DOJ and 12 other state AGs to block the merger successfully. I was working with Anthem Humana at the same time, and I can guarantee you that we had quite a large group of state AGs on that as well. On that transaction. And so it's very typical. That's a perfect example of how the state AGs will work closely with the DOJ, be involved in the investigation and the litigation to block a suit. Valero Energy is another example of where, in this case, it again was something where the FTC had decided, it's okay. And then California went and challenged the transaction. California was concerned about the market dynamics in that area. They didn't win the kind of the preliminary injunction, but the courts basically the court's dicta about his views on the substantive merits of the case were pretty damaging for Valero. He felt that there was some good evidence that there could be anti-competitive effects should the case proceed. And so the transaction was actually abandoned after the California brought that suit. T-Mobile Sprint is another example where you had a coalition of state AGs led by California and New York to challenge the transaction after the DOJ agreed to conditional approval based on a divestiture. The judge approved, the judge ultimately approved the deal, but California was able to nonetheless procure a settlement with T-Mobile Sprint, essentially requiring quite a number of behavioral conditions. And so they needed $15 million to reimburse the state's cost of the investigation and litigation. They were required to make low-cost plans available for 5 years, to make no-cost broadband internet available to low-income households, maintain the same level of employees for 3 years on substantially similar terms, and create new jobs. So you can see that, and let me get to the next slide. We have a number of different ways that if we see a transaction that has that presents concerns, how we can solve for those concerns. You don't necessarily have to say, no way, this transaction can't go forward. There's ways that sometimes you can, solve for the concerns. The preferred remedy is what's called a structural remedy or a divestiture. And that is, that basically says, okay, here you want to merge 2 companies, but we have a problem in this overlapping business unit. And so essentially that says carve that out, sell that to a third party to preserve competition in that. And then the rest of the transaction can proceed because we don't have concerns. You don't compete in these other business units. If you are going to go through a structural divestiture, typically, the guidance that the DOJ and FTC has provided is that you have to make sure that that divestiture includes all the assets necessary for that divestiture buyer to be able to compete. Standalone businesses are preferred so that you don't have this intermingled. It really goes to that all assets necessary, making sure you have all of the support functions and everything else you might need to be able to create a viable business that is able to continue and compete well. And then the buyer itself can't cause competitive harm. It has to be able to you have to show that they have the incentive to use those assets to compete and not just grabbing the assets in a fire sale, because typically these are fire sales with a very short time frame. And so they're sold for a fraction of their worth, and that the buyer has, is fit. So they have the business acumen, the experience in running, some type of experience and expertise in that industry to be able to shepherd these assets in a way that's going to be competitive, and the financial viability capability to do so. So the structural remedies have certainly been the preferred remedy for the federal antitrust agencies. However, this year, we have seen a shift in policy at the DOJ. The DOJ has announced that they are not, really considering structural remedies. And so we haven't seen, well, this has typically been how parties have resolved their concerns. We have not seen the DOJ accept a structural remedy. They essentially feel, fix it first, don't come to us with a problematic transaction. And so what you have started to see is you started to see a few more companies who are doing that, who are essentially structuring their own transactions, their own remedies, negotiating that. And then, we have had a few cases that have gone to litigation. Essentially, it's called litigating the fix, where the court then has to evaluate the transaction with the proposed divestiture in place to determine whether overall, what is the impact on competition once you have that divestiture in place. And so, so we have seen a little bit of a departure there. The second type of remedy is conduct behavioral conditions, essentially. And that's what we've seen the California AG do, right? So when we talked about T-Mobile Sprint, those impositions, what we've seen and we'll get into some of the other, cases that they've looked at, but it's really saying, if you want to go forward with this transaction, this is what we need you to do. Now, the federal antitrust agencies have shied away. They have not generally accepted behavioral remedies because they don't want to take on the role of regulating price, monitoring compliance, and essentially, kind of being this, pricing and behavioral police, right? They're saying, look, our resources are already stretched thin just trying to even say whether a transaction can be approved or not. We don't have time to babysit you. And so, but California AG has been much more willing to adopt these type of, remedies. They typically include some sort of monitor. So an independent monitor who gets reports from the companies who can then report to the, California AG as far as compliance and how the companies are doing. It requires reporting from the companies. Some of the remedies that we've seen from California have included price regulation. We'll get into some of those in the healthcare context. Prohibition on certain practices, right? We saw that in the Sutter settlement, even though it wasn't necessarily tied to the initial transaction. Some transactions have required mandated licensing or continuing to supply, especially in vertical transactions, continuing to supply or putting into place a firewall, especially if you have a vertical transaction with a customer, with a supplier and a competitor, to ensure that different parts of the companies are not receiving competitive information about, competitors on a different level of the supply chain. So there's a number of different conditions that can be imposed. Again, federal agencies have not been very willing to adopt those types of remedies, whereas California has shown a willingness to do so. So getting into that, as an example, California does have, states currently do not have pre-merger notification programs across the board, a general one. California does, however, have a pre-merger notification program in place for healthcare transactions. So they have had, under California Corporate Code Section 5914, pre-merger notification for non-profit healthcare entities. So transactions involving health nonprofits where there's a material change in control, essentially. And under that authority, the AG has investigated and imposed some significant behavioral conditions on hospital transactions. So Cedars-Sinai, Huntington, Acadia Adventist, USC Methodist are all examples in the past 3 years that reflect exactly that, right? And as you can see on the slide, there's a number of different conditions that California has imposed. So they didn't say you can't do your transaction. They didn't block the transactions, but they said it's conditionally approved. Here's all the things you have to do. So in Cedars-Sinai, Huntington, they put in, you have to negotiate, you have to keep your negotiating team separate. We don't want you to use your combined, volume and market power to negotiate better terms with the payers. We want you to have a firewall in place between those negotiating teams. So you still have to essentially negotiate as though you were competitors. They imposed price limitations across all services, and that price cap was tied to the US hospital index price. They provided payers with an arbitration right if the payers determined that the rates that were being proposed were not fair, and that they were, essentially leveraging their position because of the affiliation. They were required to maintain specific services to provide for the community for 10 years. They were required to provide free care annually, $5 million for 5 years, and also $30 million in community benefits. They're required to maintain their medical staff, maintain their seismic compliance, maintain reproductive health care for 10 years and no discrimination against LGBTQ individuals, and also continue to fund $560 million in capital improvements through 2029. You see very similar terms in the other transactions as well in Acadia and USC. So price freezes, price increases can't go over 6%. Acadia couldn't burden Adventist with debt to impair its financial viability, and imposition of a monitor to be able to ensure compliance with all of this. And USC, you have very similar, the same type of terms that you've seen in Cedars and Acadia. So you do see the California AG taking a quite different view from the federal antitrust agencies. That applied to nonprofit. There has been attempts that have failed previously to try to expand this pre-merger notification regime to for-profit entities, and they failed before. But the California Healthcare Quality and Affordability Act did pass last year. It will become effective in 2024. This is going to be quite interesting. It does a number of things. It establishes an Office of Healthcare Affordability in order to essentially do the work for the state AG, to review these transactions, investigate them. They have investigatory powers, so they can subpoena the parties, they can subpoena third parties, and merging parties have to provide 90-day written notice to OHCA. So that they can do their cost and market impact review. The transaction cannot proceed unless they actually issue a waiver or a final report. And the OHCA will essentially refer, when it feels that a transaction is problematic, it'll refer its findings to the AG. There's going to be a public report, opportunity for public comment, and the healthcare entities must reimburse OHCA for the costs incurred during this review process. The rulemaking is underway. It's going to be quite interesting to see how this actually impacts what the timelines are going to be, how this impacts mergers that are happening in the healthcare space. It applies to insurers, except for those that are regulated under Knox-Keene, which will be reviewed by the Department of Insurance or DAHC. It applies to hospitals, providers, pharmacy benefit managers. It doesn't apply to not-for-profit nonprofit entities because that's captured under Section 5914. So, we're expecting that transactions that have to go through this review are likely going to probably face, if they are investigated, if there is a cost and market impact review, that this could delay transactions closing, for potentially a year. So it's going to be a quite lengthy process. So we'll see how this is implemented. I'll be curious to see what the rulemaking looks like, but this is something to keep in mind. Now, with healthcare is, in essence, it is local. right? So you can have, of course, you can have health systems, provider systems, insurers that cross outside of state boundaries. But essentially, if you have a healthcare provider, they are providing local healthcare in California. And so having a pre-merger notification that captures healthcare, that is very much tied to California. That is a very local business that is occurring. And so, it is a industry that you can see has very clear ties to California, and you're not going to encounter, you're not as likely to encounter issues where you have entities that are trying to combine, that have, multi-state presences, and then you could end up having this patchwork of pre-notification if you start to depart from, the federal notification policy. This is one of the concerns that came up when New York tried to propose a pre-merger notification program. And their pre-merger notification would have been the first state pre-merger notification program that applied across the board, that wasn't industry specific. There was a Senate and Assembly bill that mirrored each other. They failed. And there were a lot of concerns about what this pre-merger notification, a separate independent state pre-merger notification process might do. That's separate from just providing the state AGs with a copy of the HSR notification, for example. Under those bills, the threshold would have been incredibly low. It would have been 9.2 million of a deal valuation. And this would essentially, if you look at data on publicly reported transactions, this would have increased the volume of reported transactions by 20 times of what the federal antitrust agencies receive. And it would have imposed a 60-day instead of a 30-day waiting period on these transactions. So there were a number of, critics that were concerned about this, including the ABA. And some of the things that they've highlighted was the burden on the state to independently review submissions and investigate. So the staffing and budget concerns. In comparison, the FTC's 2023 budget is 430 million. The DOJ's budget is 225 million. And they have approximately about 1,500 employees who are experts, and all they do is antitrust. And you also have the existing cooperation between the DOJ, FTC, state attorney generals to jointly investigate transactions that already exist. And then also just the cost and burden and delay imposed on those non-problematic transactions. So as we saw earlier, about 97% of the transactions currently reported don't pose any antitrust concerns. Okay, you also have the EU, the EU and its member states is another interesting kind of comparison point. There you have, jurisdictions, countries that have their own merger notification regimes. France has its own, Italy has its own, Spain has its own. But then the EC can also investigate. And so they've essentially, worked out how are we going to have, essentially this overarching EC review, and how are we going to square that with individuals, member states being able to investigate transactions that impact their countries. And so, the first standard is that the European Commission reviews large mergers over 5 billion, over 2.5 billion. That have an EU dimension. So the transaction has to have a significant revenue across certain, 3 member states. And if any, and the EU dimension is not met if over 2/3 of the parties' revenues are generated in one member state. There's also a referral mechanism that allows the member states and the commission to essentially coordinate with each other. The parties can, basically apply to, the member states and the commission, so everyone can discuss who should have appropriate jurisdiction in a review. And it allows them to transfer the cases to the most appropriate authority. So you have a one-stop review instead of having to go through, a number of conflicting or potentially duplicative review processes. Okay, any questions on that before we do a whirlwind tour into substantive merger review? Okay, yeah. Not hearing any. Okay, so shifting gears. What is it that all of this merger notification is trying to.
Professor, I'm sorry to interrupt. Commissioner Simpson raised his hand. He has a question.
Okay, great.
Yeah, I'm go back earlier in your slide. You talked about California in some cases where mergers were approved or not reviewed by the feds. California sort of intervened, and there were conditions imposed that California wanted. Are those on multi-state corporations, or does California only have jurisdiction to sort of second guess the feds in companies that are California, located in California only?
Yep, that's a great question, Rick. And so in these, you can see just from the party names, I brought that slide up again for reference. T-Mobile, Sprint, obviously multi-state, right? Valero, multi-state, Anthem, Cigna, multi-state. And so you can, if there is in these cases, there's also cases of, like, for example, the Colorado AG also departing from the FTC's, opinion in a case and bringing their own, challenge and negotiating a settlement. And so if there is anti-competitive effects in your state, then, you have the authority under Section 16 to seek injunctive relief against, threat and loss or damage, right, by a violation of the antitrust laws in your state.
So are the conditions that are imposed on the company as a condition of the merger only applicable in your own state? I mean, different states have different conditions.
Right. And so that's a very good question. So typically the remedy in the settlement that you're trying to negotiate is something that would be affecting your citizens, right? Okay. And so, for example, in the American stores, it would have been a divestiture of the stores in California. It wasn't going to be you can't do everything. It was in California, this is what you have to do. The healthcare cases that we talked about are easy because that's local, right? Right. That's California.
So our standing to be able to do this is pursuant to federal law?
Correct. These ones are under Section 7.
Okay, and these are federal courts in which we go to court and enter. So and the reason I'm asking is, I mean, part of our reason we're looking at this subject in the first place is to what extent can California legislature, come up with its own ways to think about antitrust. And so I'm trying to get in my own mind, to what extent do we have authority to the state, the legislature and governor, to create laws, structures that deal with some of the same issues that FTC and DOJ are doing with, or are we sort of limited to exercising our power under federal law to address some of these merger issues?
Yeah, Rick, that is an excellent question. And I think we could have an entire session on that interesting topic, right? What I would point to is the California, that we do have a pre-merger notification and review already under, for healthcare transactions, right? So we do have legislation that gives California the right to be able to review transactions for anti-competitive effects. Under, the California Healthcare Quality and Affordability Act and under CalCorp Code Section 5914, right? And to be able to extract conditions. And so, I think that's why I wanted to include these in the presentation, because those are examples of exactly what you're asking, right? To what extent can we in California, through our own laws, legislate and impose conditions on transactions that affect our citizens?
And the answer is yes, we have that authority.
We've done it.
Right. But could we do it? But these are sort of local companies. So if we want, could we write a law to have some authority over regulating mergers in companies that are multi-state?
So I think that that's going to be, I think that's the crux of the issue, right? Is how do you need to have essentially that jurisdictional tie, right? So if you're thinking about it, what do you have to really be able to ensuring that it's not, what is the basis? What is the nexus to California specifically that allows you to be able to do that? California state AGs have, challenge transactions of multi-state operators. I think that's where you need to be very careful about, showing that the anti-competitive effects are in California that you're trying to remedy, and then trying to tailor a remedy that is really is able to deal with the effects in your state, right? So you don't have that extra jurisdictional reach.
Okay, well, that makes it a lot more, I don't know, complicated, nuanced or something in terms of trying to deal with antitrust issues and mergers on multi-state.
Yeah.
Okay, thank you.
And so, again, that's a topic that I think is it's a fantastic question. I think that's a topic that we could spend an entire session talking about, that goes a little bit more beyond necessarily antitrust and more into, just what you can actually, kind of like the state rights and preemption and things like that, as far as what is the reach that you can have, with your laws versus other things. And so I have to confess that I'm not equipped to lecture on that right now. And so, but excellent question.
Thank you.
Sure. Anything else? Okay. So what is it that we are actually, what do our current antitrust laws, following up on Rick's question, Section 7 of the Clayton Act is quite simple, right? It prohibits acquisitions that may substantially lessen competition or tend to create a monopoly in any line of commerce or in any activity affecting commerce in any section of the country. So let's unpack that a little bit. May means, again, we're doing a predictive exercise in most cases. Is there a probable effect of substantially lessening competition? And then in any line of commerce or in any activity affecting commerce in any section of the country has been interpreted by a number of courts to imply that you need to define a relevant market, a relevant, product market, and a relevant geographic market. There are commentators, for example, Professor Louis Kaplan, who thinks that you don't need to do that, right? That is not, if you look at the legislative history of Section 7 of the Clayton Act, that's not what's intended. And instead, a very reasonable interpretation of in any line of commerce or in any activity in any section of the country is that language was actually intended to capture if there's an anti-competitive effect in the country, in any business, it's a violation. And so, again, coming back to that question of, do we need relevant market? Do we need relevant product? What is the basis for that? Now, a number of courts have held that does mean it's a relevant product or relevant market. And that's why a number of cases, like we saw in Summit Sutter, have failed because parties have failed to allege a probable relevant market. And so it's one thing to keep in mind as we go through this. A brief history lesson as far as how Section 7 of the Clayton Act has been applied and interpreted. In the 1960s, we had a series of Supreme Court cases, Brown-Shoe, Philadelphia National Bank, that essentially established what's called the structural presumption. And what this means is we first figure out what our relevant market is. And so what are the goods that are reasonably interchangeable? And by that, a common test is, would a hypothetical monopolist who had all the goods in the proposed market be able to impose a 5% or more price increase profitably? And so that's how, we kind of draw a circle. Once we have that circle drawn, then we're like, okay, what are the market shares inside that circle? Who are the market participants? And then calculate market concentration. Based on that market concentration, then we say, okay, structural presumption is met. The transaction is presumptively anti-competitive based on these concentration metrics. And now the burden shifts over to the plaintiffs, to the defendants, to prove that our market concentration inaccurately predicts anti-competitive effects. So that's kind of where we're at, where we landed now after all of this. So 1960s, that structural presumption emerges. During those times, there really wasn't much of a rebuttal case. The government was winning all of these cases. It was, there was a very strong tendency to protect small businesses. So you have to think about the laws and how they were being interpreted in the kind of political environment at the time. So there was a large incentive to protect small businesses. There was a sentiment very wary of firms gaining too much economic and political power because of their size. It was a time where you saw a lot of increasing concentration. For example, the small mom and pop stores being bought up by large grocery chains. The small, shoe store being bought up by a larger, shoe chain. And you also saw during this time that efficiency concerns were outweighed by, by really a concern for decentralization, right? To stop that type of increasing concentration in its incipiency. So you saw very low market share thresholds that the court was using to essentially block a transaction. And you have Vons Grocery and Pabst Brewing, where you had market shares as low as 5%, we still block those deals. Then in 1970s, you started to see a shift. You started to see a number of cases that started to kind of crack open the door to allow, the government stops winning all the time. And so the first one was General Dynamics, where they essentially said, if you have changing conditions, that rebuts, that shows that those market shares, that current concentration that you have today doesn't accurately predict the anti-competitive effects that might happen with this transaction. In that case specifically, they looked at future reserves and realized that, the merging parties had very little reserves. So they wouldn't really have been a competitive constraint, a competitive force going forward. What's important to note is that the last Supreme Court merger case we had was in 1975. So we haven't had the Supreme Court really, opine on what should merger policy be, how should we be interpreting the Clayton Act since then. And since 1975, we have had a pretty significant shift in how we look at these antitrust cases. You've had in the 1980s, you had the Chicago school perspectives really start to take hold. And by Chicago school, I mean an emphasis on the market can take care of itself. It's going to move to efficiency. We really need to be looking at efficiency, and you don't want to block transactions that could cause a more efficient market. And so during this time, you have Reagan appoint a number of Chicago school-oriented federal judges who really were influential in antitrust law. Outside of, not necessarily tied to the merger context, but, in all sorts of, in a number of shaping antitrust law, the rule of reason, being able to really move and appreciate efficiency concerns and justifications. And you also see the merger guidelines revised during this time period to reflect that evolving viewpoint of let's take a look at what are the efficiencies. Let's take a look at market power. Let's take a look at effects and starting to look at that more and more. So you see that happening, really kind of an increasing emphasis on the totality of circumstances. Market definition is only a starting point. Let's really look at what's happening in this market. Let's see all of the different factors involved to try to determine what the ultimate effect might be. So that was what our merger guidelines looked like. They were revised most recently in 2010. The 2010, I attended the merger guideline workshops. During that time, there was a lot of debate about, do we still hold on to market definition? How should we adjust the market concentration numbers? Are concentration numbers even, are they even useful? Do they actually predict anything about anti-competitive effects? So there's a lot of literature out there, a lot of economists who, are adamant that market concentration is not correlated, significantly correlated in any way with market effects, right? And so, we have all this emphasis. The analysis currently is really based on defining that market and calculating market concentration. But what does that really tell us about the marketplace? Is that where we should be starting? And so, there's a lot of literature there. And, I think some of how that has, and what's been reflected in the 22 horizontal merger guidelines is the notion that, you can show anti-competitive effects directly, right? There's other ways that you can show anti-competitive effects. And in fact, the very data that we use to determine a market definition, right? That can someone impose that 5% or more price increase? You're looking at diversion and you're looking at profitability. Well, if you have that data, you can actually make predictions about what the merging parties would do based on their diversion and their profit margins. And instead of trying to first, define a product market, then calculate concentration, you can just say, well, do they have an incentive to increase price? Are they going to recoup enough lost customers that they can actually profitably impose a price increase? And so it cuts out entirely the need to even define a relevant market in the first place. Now, we still do that because under current federal court precedent, there's a requirement that you prove your relevant market. And as we saw in the Summit Sutter case. So, okay. So as we've been talking about with horizontal merger review, you really start with that market definition. In most cases, that's how even if the agencies aren't evaluating cases that way, it's how they're going to draft their complaint. And so it's a very easy way for them to say, here's our market concentration. It's presumptively unlawful. The way you measure concentration is it's literally squaring the market shares and adding those all up together. So, we big numbers equal bad. We us lawyers like that simple math. It seems easy, but what does it really predict? What is that showing us, right? And so currently the level in the 2010 horizontal merger guidelines is if you're at over 2,500 HHI, that means that it's a highly concentrated industry. If the transaction increases the HHI by over 200 points, you are then presumed to be an unlawful transaction. And then burden shifts. So burden shifts over to defendants in that case to rebut the presumption, show that it doesn't accurately depict the effect on market effects. And you look at the totality of circumstances. So we also review vertical mergers. So it's not just horizontal mergers. And in vertical mergers, you're really looking at, will the transaction provide the parties with the ability and the incentive to, act to cause anti-competitive effects. Anti-competitive effects can be increasing pricing, lowering quality, lowering service, less innovation, etc. And so the idea there is, do you have the ability? Do you have enough of market concentration in one level of the supply chain? And then do you have the incentive? So you're willing to cut off your customers who are now also your competitors, or, if it's upstream, then your suppliers who are now also your competitors, because you're going to make more money by foreclosing them or rising their costs because you get to recoup that if you're then winning that business on that, downstream or upstream level than you would have otherwise? Or do you have the incentive because of margins of the different products to continue to, compete as you had been before? So the FTC rescinded the vertical merger guidelines last year. They are skeptical. They are very skeptical. Typically, vertical mergers did not receive a lot of scrutiny. They were still investigated. But you typically didn't see transactions being challenged or receiving a lot of scrutiny because of the idea that vertical mergers have almost like an implied efficiency. You're eliminating double marginalization. You're being able to, by vertically integrating in that way, you can have more efficiently, bring products to the marketplace. And the FTC is very skeptical of that and just generally skeptical of efficiency claims. And so we haven't seen new vertical merger guidelines. We are expecting those to be integrated to have, and I should also note, as I mentioned earlier, that the DOJ and FTC have issued a statement last year that they are revisiting the merger guidelines. So we expect, we've been expecting the new merger guidelines for quite some time. There's been some chatter that it might even be this month, but we are, we're eager to see what guidance the FTC and the DOJ are going to be providing and how they are now going to be reviewing transactions. So when we talk about the totality of circumstances, there's a number of things that we're looking at, right? So we talked about how the starting point has been market share HHIs for most cases. What we're looking at are there unilateral effects? So will the combined firm have the market power to increase prices, quality, decrease quality and service, lower innovation? But then there's also coordinated effects. And so coordinated effects are, does this transaction essentially, change the market dynamics in a way, for example, eliminating a disruptor that would enable enhanced coordination? So tacit collusion, for example. So that the parties, if there's an oligopoly, they can more easily, essentially follow each other's pricing and come to price rationalization. So that's what we mean by coordinated effects. In order to rebut that, we take a look at entry. Is entry going to be timely, likely, and sufficient to actually replace the competitive, things lost? Waste management is a perfect case of that example. The court found anyone in their pickup truck can basically start collecting garbage. And so, that's a great example of where entry would be able to come in position. And so no one would be able to sustain a super competitive price increase because entry, other firms would be incentivized to come in and compete in that area. Of course, you have to look at barriers to entry to evaluate whether that's, credible. Efficiencies is something that, it's been a pretty narrow defense. The problem with efficiencies is that, the current understanding is that they have to be merger specific and verifiable. And it can be quite difficult to verify what your efficiencies are other than HR reductions, which might not necessarily be something that you want to happen, as we've seen in the California AG settlements, where they've actually wanted to ensure that, labor forces are, continue, and that jobs aren't lost. And so, to be able to verify what the efficiencies are from a particular transaction, sometimes it's a business plan where it's an innovation. It's creating value. It's creating a unique value proposition that hasn't been tested before. That is a new way of coming to market or doing something, right? Value-based care is a good example. If you have, healthcare systems coming together to be able to create population health, to do value-based care, it is going to be hard to necessarily quantify what that efficiency is. And yet it could be quite a tremendous efficiency. And so, so currently efficiencies have been very narrow and increasing skepticism by the federal antitrust agencies as far as what they will accept. So the question is, should we continue that way, or should there be, when we're looking at the totality of circumstances, have a broader kind of recognition or willingness to review what might be the transaction rationale and what is the good guy story? Is this a good transaction or is it a bad one, right? Like, let's step back and just think about how this is going to likely play out. And so the question is, but how do we measure that? And then a couple other things that we take a look at: failing firm can be a defense if the assets are going to exit the marketplace, like they're not going to be able to reorganize. They're going to have to go through litigation. This is a company that is no longer going to exist. It's no longer going to be able to compete. In order to, in those very limited circumstances, some transactions can be approved, even if it would be with a very close competitor who would raise antitrust concerns under normal circumstances. But the other criteria that they have to meet is that there isn't a more attractive alternative buyer. And so if there's another buyer, even if they would have paid less money for the same assets, but they would not have posed the same antitrust concerns, then the failing firm defense doesn't apply. We also look at whether there's power buyers who are sophisticated, who could sponsor entry, who could negotiate their own terms, who could vertically integrate to protect themselves. So those are some of the things we look at. And then monopsony concerns. Monopsony hasn't played a very prominent role in most merger investigations, although it's an area where I think we're probably going to see some increasing action. And by that, we mean, everything that we're looking at is essentially the seller power, right? Like, are we going to be able to impose higher pricing? Monopsony is, are we going to be able to impose lower costs on our suppliers? So for example, if you have a milk processor who is combining, are they going to be able to essentially negotiate much lower prices from milk farmers that are going to drive them out of business? That would be, not good for our California dairy farmers if that happened, right? And so looking at monopsony, not just focusing on, do we have the power to impact our, our buyers, but how are we impacting, how does the transaction affect people who we're purchasing products from? So as I mentioned, there is the merger guidelines reform underway. The FTC and DOJ are looking into this. There's been a lot of commentary. I think over 5,000 comments were filed. And what they're looking into is, how do we best regulate transactions to ensure that against harms of higher prices, lower wages, diminished opportunity, reduced innovation, and less resiliency. Now, this is interesting because this is a broader spectrum of concerns than what we've typically seen in merger review. Typically merger reviews haven't focused on lower wages. Typically merger reviews haven't focused on diminished opportunity or less resiliency. And so, it's really kind of broadening it from just looking at a very clear, what's the price effect? Are we going to see increased prices in this and use that as kind of a proxy for quality and service as well? Okay, so this also leads us to questions about some evolving issues that we're seeing in the marketplace today, right? Under our current framework, again, the Section 7 of the Clayton Act is very broad, right? Simple, does it substantially lessen competition? The question is, in how do we actually apply that? What is the analysis of how we're looking at that? What is the framework of how we, kind of acknowledge that? And so, questions that we need to think about, especially as you're considering legislation, is potential and nascent competition. Are we concerned about large companies gobbling up startups to create a competitive moat? And how do we measure that and how do we block that? If it's all about market share and market concentration, well, that tiny company might be a blip on the radar right now, but they might have some pretty impressive tech that might change the entire landscape, that might disrupt the entire industry, right? And how do we measure that if they don't have revenue yet, or they don't have market share yet? And, so and this comes up in pharmaceuticals a lot when when you have acquisitions of pipeline drugs, how do you actually what are the standards that you put in place to be able to, measure that, enforce about that, and look at that way? Another one is serial acquirers. What happens when there's consolidation happening in an industry, but it's a number of small cases? So just like startups, if you have a lot of tiny mom and pop shops, right, not a single one of them is really a significant market share participant, but you have 10 acquisitions and then you start to, really start seeing a shift in what that market looks like. Again, if we're looking at, if our whole analysis is based on market definition and market shares and concentration, that analysis might be missing this. What do you do when you have non-price competition, right? Or zero priced products? And so it's really about, and that kind of goes into multi-sided markets as well, where you have two-sided networks. And in that situation, you might have different market shares on both sides, right? And a lot of times on these two-sided platforms, one side of the platform, you might have a zero price product to be able to encourage people to join your platform, to then be able to increase, your market position on the other side, right? And so when you think about these different types of situations, buyer power, we just talked about on the previous slide, But they're all situations in which, you know, if you're stuck in a box of having to define a relevant market and calculate concentration numbers, you might be missing something, right? And what about conglomerates or just, you know, companies that have a significant market position that allows them to have that type of buyer power, perhaps in supplies, that allows them to have a competitive advantage over the smaller guys. And the bigger they get, the more that they have in that. Again, it could be like a monopoly soup, right? They're larger, they have that power, they can negotiate exclusives, they can negotiate, they can, you know, force their customers to accept bundling, to have, and of course we have antitrust laws that also, you know, prohibit some of that, and that can be violations in themselves. But, you know, they can negotiate terms where they get priority supply over their competitors. A number of different elements that, you know, companies, and they might not have significant market share in, for example, one narrow relevant product market or geography market. But the fact is that they might have a very extensive position in a much kind of more amorphous, you know, market position, right? Where, you know, they have negotiating leverage. They, you know, their stock price, you know, they're able to hire the best talent because, you know, because of what their market position is, for example. And by market, I don't mean in a specific antitrust relevant product market, right? And so thinking about all of that when you consider, you know, where do we go from here? And data aggregation is another question, right? Where it could be data aggregation, it can also be supply. So, you know, does someone have, and that kind of goes to that question of, does someone have enough power? Are they capturing, you know, significant inputs that provides them, that creates a competitive moat, that puts them into a position that creates market power? And then if so, how do you define that market power? Do you have to define that in the box of a relevant product and geographic market? So, questions?
Professor, thank you for the excellent, very comprehensive review. This will help the commission greatly in the work ahead. I have one question, which is about your last point. Have you seen antitrust cases involving data aggregation claims?
I currently haven't seen that. And I have to in my, you know, my private practice, haven't been involved in that case specifically. There is literature out there. You know, I'd have to see whether I'm not currently aware of a case, but again, that just might be because I haven't specifically researched that topic. And so.
Brian, do we anticipate a session on data and data aggregation? Brian, you're on mute.
I don't have one scheduled. I could. You know, we have the second half of this year for presentations in meeting. One of those, you know, there was a request at the last meeting for presentations from the folks involved in the New York legislative attempt and congressional legislative attempt. I'm working on that. There was also a request for presentation by behavioral economists, and I'm working on that. I could add data as a separate topic to one of those presentations as well.
Now, rather than just going ahead and adding it, it might make sense to do a little research to see if there's much there that would warrant the presentation. But it seems it might be an important issue for the task we have ahead. Yeah. I just don't know what the landscape looks like.
David, that is an area that is certainly a hot topic, right? And so there are comments specifically to the merger guidelines on, you know, how should we approach data aggregation? That was one of the things that the FTC and DOJ are looking at specifically. And then, you know, in addition to data aggregation is also, you know, and another antitrust question is just kind of algorithmic pricing. What does that mean? So there's a whole host of things that are involved in that you can kind of put into a topic on data aggregation. I just have to admit, like, I don't want to speak, because before opining on some of that, I would want to just have done a little bit more literature on what the varying viewpoints are on that before sharing my views myself.
And David, I would add that in the small groups of experts that we've organized, one of those is looking exclusively at technology platform issues. And so their report might encompass some of the content that you're interested in, and we could rely on that rather than having this kind of tutorial presentation that we just had and that we got from Professor Green. I'll look at it more to see whether it makes sense as a potential in-meeting presentation. And we can discuss it again, perhaps in June.
Well, I think we should rely on your judgment after you've been through it.
Okay.
Are there questions or comments from any other commissioner? Are there any questions or comments from our staff colleagues? Hearing none. Once again, Professor, thank you for taking so much time and coming this morning to present to us. Much appreciated. And
Well,
thank you to the anonymous Professor Green as well for sitting in.
Well, thank you very much for this opportunity. It was quite exciting and quite a privilege to be able to share with you all today and the important work that you're doing. So I am very happy to be part of this effort. Thank you.
Thank you very
Thank
much.
you. Now, Kristen, before we resume, it's been an intense 90 minutes. Commissioners might be a little tired. Commissioners, should we take another short break before we do our final bit? I hear no objection. Let's convene in 9 minutes at the half hour.
Okay, got it.
Brian?
Yes.
I have a question. One of the commissioners did not remember us voting to approve the minutes, but I clearly recall we did. Am
Yeah,
I
believe
correct?
so. I think so too. I have a note that it was approved.
Okay, great.
But before, part of our process of preparing minutes is that we listen to the whole meeting again. So I will make a point of making sure that that's correct. And if not, we can address it in June.
Okay, very good. Thanks.
Uh-huh. I heard from Sochi that she had to pick a sick kid up from school, so can't attend.
Okay. Having established a quorum under our rules, do we lose the quorum or are we fine?
No, we're fine.
Very good. We're all back. Back in session.
And I would say that the trial court restructuring memo could easily be kicked over to June. There's no urgency at all. I'd rather spend the time on Kristen's topic today.
Okay, well, let's see how far we get. Kristen?
All right, so I think the main remaining issue that is covered in the memo is freedom of speech. And I want to acknowledge specifically for freedom of speech that I don't attempt to cover that doctrine exhaustively. That's true generally, but even more so in this context. I think there are other specific areas within freedom of speech that may involve issues of sex equality. One of those is flagged in the memo related to criminal and tort law issues involving like stalking or harassment. Instead, this memo focuses on a doctrine called the compelled speech doctrine, where the claim is essentially that someone is being required to speak a message with which they disagree. And the memo just provides several concrete examples of when this doctrine has been raised in the case law. One of those examples relates to required notices that had to be provided at certain facilities that provided pregnancy-related care. In that case, there were two different notices that had to be required depending on whether or not the facility was licensed. The memo describes the details, but effectively the court concluded that both of the required notices, whether it was just simply a notice that the facility was unlicensed and not able to provide medical services, or a more robust notice involving what sort of services might be available at low cost or for free from the state of California, both of those notices were potentially violated the First Amendment. So the memo also discusses the parade participation case, which we've already talked about, and limits on sort of expressive speech. And the next set of cases that are talked about are the cases involving same-sex weddings, and specifically Masterpiece Cake Shop and the currently pending case 303 Creative. As was noted earlier in the meeting, the Masterpiece Cake Shop did not end up really addressing the compelled speech issue, but instead resolved the case on different grounds relating to the purported hostility of the commission towards the baker's religious beliefs. But I think the expectation is the 303 Creative case involving a website designer will perhaps more directly address the compelled speech issues. So I guess the main takeaway from that is this area is there may be a big decision coming down, and so it's not really clear what to say about that. The other item that I noted was preferred pronoun policies, and there have been a number of disputes. Some of those are having more employment claims, but the cases might also involve compelled speech claims. The litigation typically has not gotten up, it hasn't reached the Supreme Court, so there's not any decision, but there are kind of a number of different cases at different stages. And so I just wanted to acknowledge that that's another area where those claims are being made. It's in this case, I think it's particularly hard to sort of know where this doctrine is going, but certainly it seems like that people are seeing room to make these claims. And so this might be an area where there's more legal developments on the way. So I don't know if there are any questions from the commissioners on that.
Hearing none.
I guess finally, the only thing that I want to note, and which I've indicated with respect to the freedom of speech issues, is, this memo really tried to do kind of a general overview of federal constitutional protections that might, restrict what the commission can do on sex equality. There are some other areas that we did not explore that might either, directly or indirectly affect what states can do in these areas. And so those are listed on pages 36 and 37 of the memo. And where the Constitution grants powers exclusively to Congress, where there's issues of preemption, those would be more concrete and, you know, specific substantive areas, presumably. The full faith and credit clause and the situations when federal law, would not be a legal obstacle, but when federal law is conditioned on the receipt of federal funds. And there's a specific example that I provide related to school facilities that might receive federal funding. So in some cases, like the laws, like I said, it would not be a legal obstacle to California doing something there, but certainly a practical fiscal concern that we would have to be aware of. So I just wanted to acknowledge those. There's a brief kind of summary of the takeaways at the end of the memo for each of the different doctrines. The next steps we anticipate are simply addressing how the commission should sort of incorporate what's presented here into its work, and how it should shape what we do, if at all. So that we would be addressing in an upcoming memo.
Thank you. Are there any final questions, comments, or requests from commissioners? Hearing none. Brian, how much time would you estimate trial court restructuring would take?
Potentially very little.
Well, why don't we start it and see how we go,
All right,
since we're all together.
it's memo 2328. And it presents a draft of a tentative recommendation. And really the only sort of novel aspect of it is that the issue that's discussed in the tentative recommendation, the commission had previously decided to hold that issue for eventual inclusion in an omnibus recommendation on trial court restructuring. I think based on a sense that it's kind of too small of an issue to stand on its own and that we would eventually just bundle it. But as I say in the memo, you know, our work situation has changed substantially this year. And I really don't think we're going to be getting back to trial court restructuring for a couple of years. So we could, if we want, accelerate this and just make it its own TR. But we could also not do that because I don't think it's an urgent matter. It's just a cleanup. There is this statute that refers to a method by which counties would calculate the distribution of certain revenue to the courts. And we have heard from the Judicial Council and from the State Controller's Office that that method's not used anymore. And so the proposal is to repeal the section that addresses the use of that method. And the input we got was informal. It was staff level, which is helpful, but not entirely reliable. And so the purpose of the tentative recommendation would be to sort of shake the tree again and see if we could get firmer information or a different view. So the proposal would be to approve the tentative recommendation, and we'll just distribute it with or without any changes you might want to make, or hang on to it for later.
It would seem, correct me if I'm wrong, that there is no harm in proceeding. Or do you
That's correct.
see a downside?
No, it was just an issue of efficiency more than anything. And circumstances changed where that expected efficiency is not going to be available to us for a couple of years. So we could just do it in a way that's less efficient, but the work's already been done. So it's just a matter of putting the finishing touches on it and posting it, distributing notice. So it's really not much work to circulate this.
Okay. Do you need a motion on this or just a sense of the commission?
Yeah, I think a motion and a vote would be good.
Is there a motion?
Sure.
Commissioner
I'll-
Simpson,
I'll-
is there a
I'll move that we approve
second?
it. I mean, this is the kind of thing you should be stuck in an omnibus bill somewhere, right?
Yeah.
Exactly.
I'll move approval.
Commissioner King seconds.
Yeah.
Brian, would you call the roll?
Yes, I'm going to do it based on the order on my screen. So Hebner,
Aye.
Simpson,
Aye.
King,
Aye.
Jenkins.
Aye.
Thank you. That's sufficient.
Our pleasure. Brian,
yeah.
is there any other business?
No, just a reminder that the June meeting is going to be an hour earlier than usual because we're hearing a presentation from someone in London. So our 8:30 is going to be her 4:30.
Okay.
All right. Thank
Okay.
you all. Good meeting.
Very good.
I will
We are
follow up
adjourned.
about the interviews separately.
Thank you.
All
Have a
right.
good day, everyone. Thank you.
Great.
Everybody.
Thanks.